So mom and dad come into my office and they're going to create a trust because they want to avoid probate, and they have some rules and restrictions they want on everybody that stands to inherit from them. And then we start talking about who's going to be the trustee to make sure that all of the rules are done correctly and that all of their property goes to the people they want it to go to. And they start going back and forth on, well, Jim is going to be really upset if he isn't the trustee because he's the oldest, but Martha's really better with money because she's the CPA, but maybe we should have Sally do it because she gets along with everybody better. And they start talking about it. And I can tell you that most of the time, they think that this is going to be some kind of honor. Being the trustee, what a lucky job. Welcome to Gavels Down, Voices Up, where we flip the script on conventional legal discussions. I'm Rachel King, here to guide you through the murky waters of family law, estate conflicts, inheritance disputes, all of the dramas. We're not just talking about law, we're talking about how it affects your life, your rights, your future, and your money. From the courtroom to your living room, we bring you insights that matter. Dive into each episode ready to challenge, learn, and grow. Ready to change the dialogue? Let's begin. Gavels down, voices up. Trustees hold a significant amount of power. And for this, we're going to talk about after mom and dad die, right? So mom and dad get to be the trustee in most cases while they're alive, but then they die. And so then this whole other person, whether it's a professional or one of the kids or friend or Uncle Joe, they're going to step in and they're going to ask or be able to administer the trust. They get all of the assets. And the reason that trustees end up having so much power is because we've given, typically in a trust, them the authority to do all of this, to pay taxes, make distributions, collect assets, sell all of it, in order to effectuate what we want to have happen. But in a trust, the assets actually go into the trustee's name. Sure, it's as trustee, but the trustee can just go in and open a bank account as trustee, put all of the money, and their name is on it. Of course, they're supposed to do what's right and follow the law and then get in a lot of trouble if they don't, but that's what gives them a lot of power. And that's also where it can get really sticky. So what happens next? Well, first we're going to talk about the easy one. You're the trustee, and my goodness, you don't want to do it. You don't have to. So even if mom and dad thought you were the greatest person in the world, or I actually have had people that, I think I had one person that named me as a trustee, and I don't act as trustees. I'm an attorney. And I said, I don't want to do this. I can't do it. It is all sorts of things, reasons that I didn't want to do it. You don't have to. Sign a declination. Say, I don't want to do it. If the trust doesn't provide for a way for a trustee to decline to act, then there are laws set up that will make it so that the client or the person doesn't have to act as trustee. So just say no. You can even start acting as trustee and say, I changed my mind. I don't want to do this. This is too much. There's other things you have to do. But quite frankly, if you don't want to do it, don't, because it's not always an honor. It is a lot of work. But now let's go to the other side. You are looking and watching this trustee administer this trust, or in most cases, like not administer it. And you're like, how can I get a trustee removed? How can we make this change to happen the right way? First, let's talk about what a trustee is expected to do, right? Let's know what a trustee is expected to do. First, a trustee is expected to manage the trust assets responsibly, to distribute trust assets how they need to be distributed, to pay debts, provide accurate record keeping, not self-serve, act in the best interests of the beneficiaries. There's so many things that they are expected to do. They are not always overseen by a court. So while they're expected to, for example, keep really good financial records, many don't understand that because they're not attorneys, they're not professionals, and there's no court sitting there telling them what to do. If they're not doing that, right? So when I talk to people, I find out what is the problem? Oh, I'm not getting communicated with by the trustee. I have no idea what's going on. It's been 3 years and we've gotten nothing. The house is still sitting there. The house is about to go into foreclosure. Taxes aren't getting paid. Brother's living in the house and the trustee doesn't care and is letting it go to crap. Whatever the case is, what is not happening? Once we know what is not happening, we can go back and say, is it the trustee's obligation and responsibility to do so? And in most cases, if it involves trust property or beneficiaries, it absolutely is the trustee's responsibility. So then what do you do when they aren't doing it, no matter what you say? First, I always say, I'm a bit biased, talk to an attorney. Why? Because a board certified specialist like myself can really give you insight on looking at what your options are and pairing up based on the law, the trust, and what's happening, where the breach is, or if the trustee is actually not doing what they're supposed to. I personally of the belief, and that what I really take into practice is that I want to solve the problem in the least dramatic way, right? So if a letter to the trustee or the trustee's attorney will get everything back in line, let's do that rather than going into court. There are many cases, I guess, especially since I'm a probate litigator, I end up in court all the time, where that just isn't enough, or giving more time isn't an option. So we go right into court. But there's always a way to get the trustee to do what they're supposed to, or to have the trustee removed. In a trust document, there are often written language as to how a trust or a trustee can be removed. Sometimes it's just a majority of the beneficiaries or the major beneficiary that can come in and just do it in writing and say, you're fired, and appoint somebody else. Other times we have to go into court. But it's important to start with the trust document itself and see what it says about who has the power to remove a trustee and what needs to happen. Again, in many cases, it's like written notice to the trustee. But you've got to have a backup trustee. A trust can't not have a trustee. So think about that as you go in to remove a trustee. Who do you want to act? Do you want to do it yourself? Is the next person that's listed an appropriate person? Do we need to go in and get a professional? And then we're going to look at what the specific grounds to remove them are. Whether or not we need a court to remove or we can do it a different way, why are we removing them? Common ones are breaches of fiduciary duty. Remember, a trustee has a fiduciary obligation. That's a legal basis. So it's a legal term to do what they're supposed to on behalf of the trust. And if they don't, if they're acting again against the best interests of the beneficiaries, putting themselves in, failing to communicate, failing to keep records, or allowing the property to go to waste, or whatever it is, that could be a breach of fiduciary duty. So that's probably the most common reason that I end up seeing, or I try and remove trustees. Mismanagement of trust assets. I once had a trustee who was being accused of keeping all of the assets in cash. Very interesting family, but that wasn't allowed. That was mismanagement of the trust assets. Even though the trustee thought that it was okay and it was the right thing to do, we're supposed to, under the law, continue to make money off of trust assets. It could be nominal, right? You throw some money into a savings account, it's going to make pennies, but it needs to be interest bearing. So the fact that this trustee hadn't done it and it had been kept as cash for a prolonged period of time ended up being considered a mismanagement of trust assets. Failure to follow the terms of the trust. Well, the house is supposed to be sold, but Joe is living in the house and, he's got a lot of family problems. He doesn't have any money. He was taking care of mom and dad for 10 years before they died. He's got some mental health issues and is just not a very functional adult independently. So we're going to let him continue to live there. Well, not only is that not following the terms of the trust that says the house has to be sold, but it also crosses over into something else. Now you're treating one beneficiary better than the other. That's not okay either. Mismanaging of the trust assets, breaching the fiduciary duties, or not following the terms of the trust are all ways and reasons that we can remove a trustee. I've said lack of communication or transparency. No, a trustee doesn't have to call you every single time they do anything, but I do, again, my practice preference is to err on the side of more communication, over communication, and more transparency rather than less. Why? Because you've got a lot of control. You're controlling a lot of assets. And then you throw in that there was typically a death recently in the family that caused the trust to need to be administered. And we got grief and all of that rolls in. And it's really hard to predict how people are going to interpret actions. So I believe more communication and more transparency is better. A trustee must communicate and be transparent and keep records.
And now for a quick break. This episode of Gavels Down, Voices Up is proudly brought to you by King Law Firm Attorneys at Law Incorporated. We're not just about winning cases, we're about making a difference. Whether it's family law, probate litigation, or standing up against elder abuse, we bring experience, empathy, and excellence to the courtroom. At King Law Firm, we're more than lawyers. We're your team, in your corner, advocating for your rights and making your voice heard. Visit us at thelawyerking.com and on the socials at The Lawyer King to see how we fight with you and for you. King Law Firm Attorneys at Law Incorporated, where your fight becomes our fight. Now, let's get back to today's episode.
What I often see with beneficiaries is they say, like, I need to know everything that's going on. I've asked for bank statements and I haven't been provided them. And it's like, well, mom just died 2 months ago. So let's give the trustee a little time to get their head around everything. And we do have guidelines. We always start with the trust. Is the trustee required to give you bank statements after 2 months, or is it on an annual accounting basis? So we do want communication, and a trustee must be transparent. Whether that's the grounds for removal are really going to be probably of all of them more on a case-by-case basis based on what the trust says, what the trustee is not communicating, and sort of the detailed circumstances around the failure to communicate or lack of transparency. Neglect or incompetence, hopefully your parents picked a trustee that was going to be competent and not be neglectful, but we don't always know. And again, throw in a little bit of grief and mourning, and it's hard to say how a trustee is going to act. If they become negligent or they become incompetent, whether that's because of dementia or they're just having a really hard grief process, or maybe they're getting a divorce or there's some other event in life going on that's making it so they can't administer the trust correctly, that would be grounds to remove. I usually like to start with just a letter to the trustee outlining what's going on and saying, hey, do you just want to resign voluntarily because it looks like we're having these issues? Sometimes they do. And sometimes they're like, nope, and we got to move on. Much like lack of communication and transparency, the neglect or incompetence is really going to be on a case-by-case situation. I once had a beneficiary call me and say, I want to remove the trustee because the property isn't selling fast enough. The property was supposed to be sold. The trust says so. It's been a year. Okay, well, on its face, maybe that is problematic. A year does seem like a long time. But once I was looking into the facts a little bit more, we had tenants that we needed to give notice to. It was a 60-day notice. From there, they didn't vacate, so the trustee needed to evict. That was a whole process in itself. Once we were finally able to get them evicted, which was, I think, about 2 months after the notice to vacate, then we were able to go into the property finally. It was in really bad shape. So even to list it for a reasonable value, and of course the trustee has an obligation to maximize trust assets when it can, we needed to do a few upgrades just to bring it up almost to code. So the year went really fast. And in that case, the beneficiary, it was not unreasonable. The 1 year was not unreasonable because the trustee had been taking all of these steps to try and unload the house. On the flip side, I once had a trustee who decided not to sell the property for 10 years. I'm not really sure why. It was vacant land, but it was still supposed to be sold and liquidated. That caused a lot of mess. Why? Because we had to keep the trust open. There was a lot of things going on. 10 years, the court even came in and said, that is too long. That trustee was forced to sell, ultimately still didn't, probably because they were neglectful, incompetent, couldn't follow it, didn't understand all of the things, and that trustee was removed. Somebody else was put in. We were able to sell the property very quickly. Personal conflict, hostility, criminal behavior or fraud are also grounds to remove a trustee. But those are probably ones that I see are the least common. You don't like your brother? Okay. You think that maybe your brother's a little bit harsh. Maybe he, needs to have his corners rounded a little bit, or he could communicate softer. That isn't typically enough to get a trustee removed all by itself. Even hostility, I have not seen that as a standalone one to get a trustee removed. Criminal behavior or fraud really depends on what's going on, how long, and what the circumstances is. I've not seen a trustee get removed because they had like an arrest or a DUI or drug charges, even though that's a criminal record and criminal behavior. It's totally unrelated. So those ones, it is grounds to get a trustee removed, but I like to look at them also on a case-by-case basis, see if we can pair them up with something else to show that the criminal behavior, the hostility, the personal conflict, the fraud is all interfering with the ability to administer the trust and the beneficiary rights. Yeah? All right. So when we're talking about how to remove a trustee, we start with the trust document itself. What does it say about who can remove a trustee and how to? That's really important. And then, again, my preference is to start with some kind of informal resolution. Can we write a letter? Can we resolve this conflict before we go blow it up in court? I love court, but my goodness, it almost always blows it up. Sometimes we need to because it's the only way. We tried, but let's start with informal attempts to resolve it, asking for clarification, asking for increased communication, asking for the house to be sold in some time frame that's going to be happening. Can we get this on track in a way that's going to be less expensive than court? You can also demand a trust accounting in writing as well, depending on what is going on, if that's one of the issues. Now, when informal resolution doesn't work, then we go into court. We can go into court on an emergency basis or on a regular basis. That's very case specific. I'm not going to get into it in this episode on what constitutes an emergency, but what I will say, because 9 times out of 10, I have to explain it to my clients, is what you think an emergency is not necessarily what the court thinks is emergent. So we have to look at it that way. But if it's an emergency, then we can certainly go into probate court and ask for either very tight orders to be put in place to stop any harm, or to remove the trustee or suspend them, at least right now temporarily, while we figure out what's going on. When you file a petition in court, it's much like all of the other courts. You're going to get a hearing date. You're going to have to give notice. We have to go in and show the evidence. It's not usually enough just to be like, my brother never talks to me. And then it will go through the process. Some of the big misconceptions that I think are important to understand about when you're going in to remove a trustee: it is not required for a trustee to commit a crime to be removed. It doesn't have to amount to criminal conduct that could be prosecuted. Different standards. So we're not looking at that. If they're not doing what they're supposed to, they're not fulfilling their trustee duties, then they can be removed. Another misconception: beneficiaries have no power. Also not true. Beneficiaries have a lot of power because they are going to inherit, and a trustee must consider what the trust says and put the rights of the beneficiary first. So typically, if a beneficiary is being harmed in some way, then they have the authority and the power, whether it's written in the trust or under law in court, to go in and to have a trustee removed. Let me just tell you, removing a trustee, while I think sometimes it's simple and I'm very happy with how quickly it happens, it is not probably as easy a process as you're thinking it is. Unless we have a trustee who's voluntarily going to sign saying they don't want to do this anymore, it can be challenging, and it is not usually as fast as you want. The most important thing is to identify the harm, especially if it's irreparable, so that we can go in and protect it while the court is deciding whether they're going to remove a trustee. We have successfully gone in and just frozen financial assets, frozen how the house, made it so that nothing can change until we flush out the trustee's ability to continue acting as trustees, so that they don't get it and then take off to Costa Rica. One thing also, maybe the last thing that I think is important is that when you remove a trustee, again, like I said, there has to be somebody to step in and act. And it's not always going to be you. It's not always going to be a family member or friend. There are not only the trust document that we must consider as to who the successors or alternate trustees are, we also have laws in place as to who has priority, who is the more appropriate person. And then when we have a lot of conflict, so many times I'll see a court come in and just order a professional or an independent trustee. We even have an entire department of government that can come in and can administer estates where there is nobody else that's appropriate to do so. So don't always assume it's going to be you. Don't always assume it's going to be who you want it to be. That's all another thing to consider when you're trying to get Martha kicked out of being the trustee. It doesn't necessarily mean that we're going to have Joe step up. It could be somebody else. While there's no guarantee to prevent trustees from screwing up, there are things that can be in place. I always tell people, like I was saying at the beginning when we started, it is not necessarily an honor to be a trustee. It's a lot of work. So think about who is going to do it the best, who has the best skill set, who can get along with the beneficiaries the right way or the best way, and tell them, ask them, do you want to be my trustee? If they don't, why are you setting them up to do something they don't want to do? I personally am a big fan of professional trustees. I think it keeps, especially if kids are all going to be the beneficiaries, it keeps all the kids on the same side of the table. But professional trustees come at a cost. Definitely research how much it's going to cost, because I've seen really affordable professional trustees that can do a really great job. And I've seen some that eat away at that trust asset like crazy. Like it makes me cringe as an attorney. And then if you are trying to be proactive, it can be really helpful to clearly identify how to remove a trustee and how to replace a trustee. Sometimes it's really beneficial to say that all of the beneficiaries can come in by majority and remove and appoint somebody else. On the other hand, maybe you have 3 kids, 2 of them get along really well, but they gang up on the third one. You don't think that's a great way to do it. Maybe you don't write it in that way. Maybe you write it in so that it has to be removed and appointed by a court. These are things for you to think about as you're drafting. Also, if you're looking at a trust, to see how it's written. But that can be one way of preventing all of the breakdown and horrible litigation. Really, destruction of families can come from bad trust administration. If you are a trustee or a beneficiary of a trust and you think there's something fishy going on or funny, or just doesn't sit well with you, reach out to an attorney. Find out what your rights are, what can be done. Because like everything else, it's easier to stop the loss and the damage than it is to go and recover it after it's already been taken to an overseas bank account somewhere else. But, Cayman Islands, who knows? I'm always interested in what you have to say. And if you'd like to come on my show and tell me your side, I think that would be fantastic. That wraps up another episode of Gavels Down, Voices Up. If you found value in our discussion today, please subscribe, leave a review, and share with someone who needs these insights. Your engagement helps us grow and impact more lives. I'm Rachel King, thanking you for listening and reminding you to speak up, because every voice deserves to be heard.